All right, good morning. We're here for an oral argument session of the Fifth District Court of Appeal. We are as obviously doing this by Zoom, so you ought to be aware that we are recording the session this morning. I'm joined on the panel today by Judge Jim Edwards and Judge Meredith Sasso. The first case that we have on the docket today is Zachary Cass Law versus Florida, a Blue Cross Blue Shield of Florida. Both sides will be entitled up to 20 minutes each for their oral argument. If the appellant would like some rebuttal, we normally keep a 5-minute default on that. But if you'd like something different than that, just let me know and I'll be glad to accommodate whatever you would like.
I'd say probably 6 would be better.
6 minutes, okay. That's not a problem. So that said, we're ready to proceed.
Okay. Thank you, Your Honor. May it please the court, I'm Joseph Brock, counsel for appellant Zachary Cass Law. Mr. Cass Law, when he was a senior in high school, sustained.
We're familiar with the facts of the case.
Okay.
Why don't you tell us something that we haven't learned from your brief? You've asked for oral argument in this case, so tell me something that I haven't read.
All right. Well, let me see if I can restate sort of the basis of our claim for coverage, and see if that is helpful to the court. So the policy is this 155-page document, which I hope the court takes.
Counsel, I'm not sure if it's just me, but I'm having a little trouble hearing you. So if you could either get your microphone closer or something. Thank you.
Right.
No, it was just you.
Okay. Anyway, and the provisions dealing with prescription drug coverage are in a section called Prescription Drug Program. And essentially they, at the beginning of that section, the section is called RXO, and it starts on RXO1. The sections of this thing are numbered basically by.
Right, why don't we get to some of the legal issues involved in the case, since that first question didn't do us any good. Your claim here is that there's ambiguity in the policy, and so why don't you be specific as to what you think is ambiguous and why you think that that there's a certain baseline required, and that baseline doesn't apply to your client.
Okay, so like I say, on RXO1, there's a general authorization for self-administered injectable prescription drugs, which includes growth hormone, which is what my client was prescribed. Okay. What's unique about that drug is that on page RXO5, in the exceptions section, or the exclusion section, there's a long paragraph that deals with growth hormone drugs, and it sets forth medical diagnostic criteria, and it's unique among prescription drugs. There's no such thing for any other drug, and they put it in there. They wrote the policy, and that paragraph addresses the requirement of the measurements of IGF-1, which is the only ground which they're denying our coverage, is that they say we needed to have a low IGF-1 for coverage. But that contradicts this provision. The provision, like I say, if you look at it, what it does is it creates 3 exceptions to the exclusion. It's all in the same sentence, which is the first sort of subparagraph of this. We've
Why is
called,
that provision not just a coverage provision? In other words, why do we look at that provision in a vacuum and not also construe the policy as a whole by including the language regarding medical necessity?
because this is a specific medical necessity provision pertaining to this drug. And it deals with the same issue that if you look at the medical coverage guideline, which wasn't mentioned to Mr. Cass Law until his appeal was denied. That term is never used in the policy. Nothing is identified as an external document. An insured is going through a labyrinth that is so vaguely referred to that you don't even know what's going on. But the thing is, this provision deals with the IGF-1 requirement. And for idiopathic growth hormone deficiency, okay, there's a requirement, an express requirement that you have a low IGF-1. And then for a diagnosis of GHD due to trauma and other known causes, that requirement is omitted. Now, their position is that every adult diagnosed with GHD has to have a low IGF-1 to be covered. Well, that contradicts what this says. And what this does is create a category of coverage, of medical diagnostic coverage, which, and I would point out, as I point out in the brief, this corresponds with generally accepted standards of medical practice with respect to endocrinologist treatment of GHD cases, diagnosis and treatment of GHD.
Your appeal, the appeal was actually as to the denial for Norditropin, is that correct?
Yeah, well, I guess first they were both drugs that were listed in.
No, I understand that, but in terms of the review that went through MCC and everything else, that was for the Norditropin, correct?
I believe so, yeah.
And wasn't Norditropin always a tier 2 drug that required advanced or prior approval?
Well, we sought prior approval and obtained it for 4 months.
Well, that was as to the Genotropin.
It's the same thing. We sought prior approval for Norditropin from
Which was denied.
From the other drug company.
Right, Prime denied that right along. Well, my question is, wasn't Norditropin a tier 2 drug all along?
It was. It required prior approval, and we sought it and obtained it, and then we were denied coverage. There's no requirement to keep on making a request for prior approval when they've denied coverage. Right? I mean, I don't see how that can be a defense after they've denied coverage. I've cited case law to that effect. That when you've repudiated coverage, you can't require a conditions precedent to recovery, or that's not a defense to their failure to pay. So the point is that this provision is reasonably construed as a specific medical necessity provision that addresses IGF-1. And if you notice, it also, not only does it talk about when a low IGF-1 is required for the diagnosis, but it also in the second paragraph of 7N, it deals with situations where the patient has to maintain a normal IGF-1 in response to the treatment, or he loses coverage. So it deals with the subject of IGF-1, and it leads the person to believe, oh, you know, I either fall within this class or I don't. But the class includes people who have been diagnosed based on by an endocrinologist using stimulation testing and a confirming history of a known cause. That it includes those people within the class of covered members. this prescription. And then they just come along. There's nothing in the medication guideline. All they do, it's not like they come up with a new and different reason. It's all they do is just sort of revisit the subject of IGF-1, and they say, well, for everybody, we're going to require a low IGF-1, or you don't have coverage. Now, if they wanted to do that, they should have done that in that provision in the policy, which addresses when a low IGF-1 is required. And
what portion of that paragraph do you contend creates a medical necessity?
okay,
Or describes that it's a medical necessity? Because I'm looking at it, it is labeled coverage and benefit guidelines. The words medical necessity are not anywhere within that subparagraph N. And the policy very clearly states that it must be medically necessary and covered, authorized for coverage. So I'm struggling to see how that is not an explication of what is authorized for coverage, and then there is an entirely separate issue of medically necessary.
well, I would say a few things. Number one, there's an authorization for coverage on paragraph 4 on RX01. So there's no need for an authorization for coverage under this paragraph. What this is medical diagnostic requirements for coverage, which is a different subject. That's what is involved.
And what portion of the paragraph what portion of the policy are you pointing to when you say it's a medical diagnostic? Is that your characterization of the paragraph, or is that located somewhere within the plain language?
Well, if you look at, let me just say this, okay? If you look at the medical coverage guideline that they've submitted, that they used as their basis, okay? In the note to the, at the end of all the subpoints, it uses, it paraphrases the identical language and calls it requirements for not being medically unnecessary. Well, anyway, it's sort of convoluted, but it basically says it's requirements for medical necessity and therefore coverage. And so they couch those same requirements as medical necessity requirements. Secondly, it's the only such provision for any drug in this policy that goes into these diagnostic requirements for coverage. And so it's reasonable to construe this as a different animal from the other drugs that don't have such a provision, where the requirement for medical necessity is done not in the policy, but by by a determination and using the, they're vague references to guidelines. So but there wouldn't be a conflict with a provision within the policy. And to me, it seems like if you have a specific provision that gives people an indication that, hey, I'm covered for this, because I have a valid diagnosis and there's no requirement of a low IGF-1, which the medical guidelines all say is not a requirement for a valid diagnosis, and that having a normal IGF-1 does not rule out a diagnosis of GHD, and that many people have a low IGF-1 that don't have GHD, and many people have a low GHD or have GHD that don't have a low IGF-1. Mr. Caslow's IGF-1 was below the median, but it was within the normal range. But again, it's not required under this provision, and it addresses IGF-1 in detail. And one would expect, if they want everyone to have a low IGF-1, that they would just say it there, and they don't do it. And it's basically like, it's like creating a class of coverage, and then coming along through this sort of secret stealth way nobody knows about until it's sprung on them, that they've got a whole different document that imposes requirements that contradict what's stated in this provision. And the very thing you thought you didn't need based on the text of this, they're saying you do need. And it's basically for a total exactly contradictory reason. They've just made the decision that you need this for coverage. Whereas here they made the decision that you don't need it for coverage, which is consistent with the practice guidelines. So I would say that it's look, they have made reference to and I would point out anyway. They've made reference to excuse me just a second, to a provision called let's see what I got right, yeah.
Or while you're looking, I just want to let you know that you are within your rebuttal time.
Okay, I'll reserve my time then. Thank you.
Okay. Counsel?
May it please the court, I'm Jennifer Mansfield from Holland and Knight, representing Blue Cross Blue Shield of Florida, Inc., otherwise known as Florida Blue. And the appellant fails to acknowledge that contracts can provide discretion to the parties to act. And I would refer your honors to the case of Kanakaris versus Kanakaris as the probably the most cited opinion by the Florida Supreme Court at 382 Southern 2nd, 1197. We cited it in our briefs. And Kanakaris v. Kanakaris, the court explained why discretion for a trial judge in that case in divorce proceedings was so important. And it stated that at page 1202 of that opinion
this is a different animal. This is a contract, and it's a contract that you all drafted. So if there's ambiguity in the contract, it's construed, against you and in favor of coverage. So why don't you talk about that? We're not talking about the abuse of discretion of trial judges in making determinations. We're talking about contractual interpretation.
Your Honor, there is no ambiguity in the contract. The contract specifically says in multiple locations that were cited in the trial court's opinion and in our briefs that the discretion is provided to Florida Blue to make coverage determinations.
Could Florida Blue change a drug that was covered into a non-covered drug during the policy period?
I'm not sure if I understand Your Honor's question.
Well, can Blue Cross change the medical guidelines during a policy year for a particular policy?
Yes, and here's the reason. The contract provides that Florida Blue makes a determination as to whether or not a requested prescription drug is medically necessary. It specifically states that medical necessity is to be determined in order to know whether it is covered. Florida Blue is the one that makes that decision. It does not give any authorization for a covered insured or their doctor to come in and say,
That's not my question. That's not my question. Just let me ask you to assume that this drug was in January of 2014 covered. It wasn't a tier 2. It was, if the doctor said you needed it, you got it. Could Blue Cross then come along in March and say, you know what, we need to take another look at that. We're going to change our medical guidelines. It's now tier 2. It's no longer medically necessary, and we're not going to pay for that anymore.
I don't believe that they would change their medical guidelines, but those are not the facts of this particular case.
I understand that. I understand, but you're acting like Blue Cross has discretion to do anything it wants to, as long as it's not abuse of its discretion.
Yes, Your Honor, because if you are looking at medical studies and determining whether or not a particular procedure or prescription is medically necessary, it is possible to have professionals have differing opinions on that. And that's why the abuse of discretion standard is necessary and why it's analogous to the abuse of discretion standard for judges. Because if reasonable people can differ, there's no abuse of discretion. So
Okay, on paragraph 7N, isn't that disjunctive in terms of requiring a low reading of 10 nanograms or less for certain conditions, but then it's or where you have traumatic injury, that 10 nanograms requirement is not there in 7N. Would you agree with that?
that's what it says, but Your Honor, as I pointed out to the trial court, the dispute about paragraph 7N and the list of exclusions is irrelevant to this case because Florida Blue never applied that to exclude coverage. And
no, but it does. It affords coverage. It affords coverage. If the growth hormone deficiency is caused by trauma, which causes a loss of pituitary function, it's within, I think the term y'all are using, the exception to the exclusion. And under the medical guidelines, are you allowed to alter that portion of the policy?
Your Honor, it's a list of exclusions. If a drug is not in a list of exclusions, that doesn't mean that the rest of the policy doesn't apply. It just means that none of those exclusions apply. So when you have an exception to the exclusion, all it means is that there's no general exclusion to the drug from 7N. You then go and apply the rest of the policy, which requires that the drug be medically necessary. And then that is a decision that the contract says that Florida Blue makes. Now, Florida law allows contracts to have a party make decisions like that. And the way that a plaintiff would have to prove breach is by showing that the discretion to make that determination was abused. Because you can't have a situation where contracting parties are
Is that abuse of discretion language? Is that abuse of discretion language contained within the contract? In other words, if a contract provides for coverage of a drug and Blue Cross refuses to provide coverage, wouldn't you just look at the language of the policy to determine whether or not there was a breach in the absence of any medically necessary, any language regarding medical necessity?
Our position is that it's unreasonable to expect a contracted party to have Monday morning quarterbacking for the millions of coverage determinations that must be made each year in the health insurance realm. We're not talking about just.
I think I understand that argument. I want to follow up on Judge Edwards' questions though, because I have the same one. What is your response to the argument that Florida Blue provided coverage in one provision and then essentially amended that coverage provision in the guise of a medical necessity provision?
We respectfully disagree that that is what occurred. So.
I'm not. Go ahead. Sorry.
Sure. Again, this paragraph 7N that's on page RXO-5 is in a list of exclusions. And when you apply an insurance policy, you look at exclusions, right? But if the requested treatment's not in the exclusions, you just go on and apply the rest of the policy. Florida Blue did not apply the exclusion in 7N to say that because it's an injectable growth hormone that it's not allowed. It was never applied at any point in this case, either before the mistake by Caremark was made or after. It just wasn't. What happened is that under the regular application of the policy, when the request for authorization was submitted, Florida Blue looked at the medical records and made a determination of whether or not it was covered. that is specifically allowed to Florida Blue. It does not use the abuse of discretion language. But Florida law provides that when a party to a contract has discretion to act, has broad authority, that that the party has to use that authority in good faith. And the good faith standard is essentially the same as an abuse of discretion. He needs to show that no reasonable person could have decided the same that Florida Blue did when establishing the medical coverage guidelines. The plaintiff never even mentioned that, never teed that issue up. Rather, the plaintiff focused on proving Florida Blue wrong, that it disagreed with the medical coverage guideline. But mere disagreement is not sufficient, because otherwise, again, you would have Monday morning quarterbacking for every coverage decision, whether it was prescription, medical, surgeries, treatments. That's why this is different than the PIP cases that were cited by the plaintiff, an appellant, because health insurance, there has too many people and too many possible medical conditions to put it all into a document. An appellant opened today's argument saying that it was a long contract of 155 pages. Can you imagine how long the contract would have to be if every single possible medical condition and prescription also had to be included within the actual terms of the policy?
Well, that's an interesting argument, but you did include this specific drug in the policy document, and you gave alternative conditions for when it would be an exception to the exclusion. I mean, so if you didn't have it in there at all, okay, that all makes sense. But Blue Cross Blue Shield chose to talk about growth hormone therapy, and specifically growth hormone therapy that was needed as a result of traumatic injury or trauma causing loss of pituitary function. And then it seems like later on that all goes away. So again, if you look at 7N, I can see the argument being made that it appears to be an exception to the exclusion, which the ordinary person thinks an exception to exclusion equals coverage.
But Your Honor, that does not read in the rest of the policy that says that the requests in the tier 2 that require this pre-authorization and a medical necessity determination. Again, it's all the different pieces of the contract working in coordination with each other, and no single element can be read in isolation. I don't think it's fair to say that an exclusion, when it has an exception to the exclusion, is automatically a grant of coverage. This is not a grant of coverage. This is a list and exclusions.
Is the insured provided a copy of the medical coverage guidelines and the drug list as part of their summary of the benefits?
They are not printed out and mailed to, but they are available to everyone online. And you could Google it today and it'll come right up.
Are they told that those things exist when they get their policy?
They are told because the policy itself says that Florida Blue has the discretion to use them. On page RXO-2, coverage and benefit guidelines, the benefits under this pharmacy program have special benefit and payment rules in addition to rules that are specific to particular covered services listed in this contract. And that's just one location where it talks about coverage guidelines. And again, the issue then is when a party to a contract has the power to make a decision such as medical necessity, that is a broad power. It just needs to act in good faith. Now, Florida Blue could just say, we acted in good faith. But the reason I started off talking about Canacaris was because it said that the trial judges were granted discretionary power because it is impossible to establish strict rules of law for every conceivable situation which could arise in the course of a domestic relation proceeding. That's very similar to what we argued on pages 2 and 3 of the answer brief, where we argued that, as I am now, that there are too many health conditions to put them all into the contract. There are too many variables to precisely treat each potential insured who might have a medical condition and how
Let me ask this.
would be applied.
You've got a provision in the contract that says if you have a loss of pituitary function as a result of trauma, you're entitled to coverage. Why wouldn't within that same provision say, however, you must show a certain baseline before that coverage is effectuated?
Your Honor, I would respectfully disagree with the initial premise. It does not say that if you have pituitary function, low pituitary because of trauma, that there is coverage. What 7N says is that in the case of trauma, it's not automatically excluded. And so then again, you go to a medical necessity determination by applying the other parts of the policy. And Florida Blue, in order to be able to show that it didn't abuse its discretion and to ensure that decisions made for millions of people through the state are fair and even and applied evenly across, develop these guidelines internally in order to show that that these decisions are not arbitrary, that they are made with consideration and thought, and frankly, they're capable of being changed. If appellant's argument is that something like this, an exclusion should be in the policy, a policy that has to go to OIR for approval. If Florida Blue decided that the state of the technology had changed to the point where they wanted to cover it, they would have to do an entire policy change. And so it would rob any flexibility to adjust with the flow of technology and medical knowledge as it passes through time. These medical coverage guidelines give Florida Blue the flexibility to account for changes in our medical knowledge, in our medical sciences. Appellant's position would rob them of that ability to be flexible. And so that's why the medical coverage guidelines are important, because they demonstrate how Florida Blue used the authority and power that it had under the contract to make medical necessity determinations to show that it was not arbitrary. It applies it equally. And here are the reasons, right? So it has to have bright line rules for that reason. And I think that it is pretty well acknowledged that in the medical field, there aren't bright lines, right? But when you're applying a policy to make sure that it applies equally, and frankly, to protect yourself from accusations of discrimination, you want to make sure that you have bright line rules and that they're based on science. And so the medical coverage guidelines are internal documents, the Florida Blue, that allows it to operate within the power granted to it by the policy itself. And therefore, as I said before, the plaintiff's burden is to show that no reasonable person would make the same decision that Florida Blue did under the circumstances. They haven't even addressed that, let alone shown that. They never even addressed it. All they established was that appellant disagrees with what the medical coverage guideline was in 2014. That's it, and that is not sufficient to show a breach of the contract. As I also wanted to mention that as far as that discretion, In the trial court, in the argument, and this is in the record at page 3086, is a transcript of the arguments where plaintiff's counsel argued to the trial court about a 2016, 2 years after the 2014 coverage determination here. The 2016 article entitled Detection of Growth Hormone Deficiency in Adults with Chronic Traumatic Brain Injury, published in 2016, plaintiff characterized it on the second page of the study, reliance on IGF-1 as an assessment of growth hormone function after PB is a standard practice, but its use needs to be reevaluated. In 2016, the use of the IGF-1 is a standard practice, according to the study submitted by plaintiff themselves. How can it be an abuse of discretion to require it if 2 years after the decision, it's still being used? We also
You
cited.
thought it was unfair to refer to that 2016 study. I thought y'all objected to that at the hearing as being unfair, and yet now you want to go back and talk about it. And again, if it was so important to have the low reading, why does 7N talk in the disjunctive about idiopathic versus traumatically caused GHD? I mean, that was just the hardest one for me to deal with.
Your Honor, that what you're quoting there is the medical coverage guideline. It's not the policy provision that's at RXO-5. The policy provision, and I see I've run out of time. Can I?
Go ahead and go ahead and respond to Judge Edwards' question, and I'll give appellant a little bit extra time if he needs it.
Thank you. The policy provision at RXO-5 is just as we described the exclusion and then the exception to the exclusion. It does not have in detail the IGF-1 measurements and such. In fact, it says one of the exceptions is deficiency associated with loss of pituitary function due to trauma. So that's why I'm saying that this exclusion just doesn't apply. It never applied. It was never applied by Florida Blue in the application of this policy. What Florida Blue did was apply its medical coverage guideline. And yes,
All right.
That is more detailed.
Thank you. All right, Mr. Brock, you've got just under 5. I'll give you an extra minute if you need it.
Okay, Your Honor. I'll begin with her claim that the exception to the exclusion doesn't apply in 7N.
I'm guessing that Judge Edwards is having the same problem with you that he had initially, which is just getting you to speak up a little bit.
Yes, Your Honor. I apologize. Okay, so she's overlooking the general authorization for these drugs in paragraph 4 on RXO-1. You've got a general authorization, then you've got exceptions to an exclusion. Those exceptions apply to the general authorization, so there clearly is an authorization of coverage here. It's unambiguous, and it's clearly something that Florida Blue had had a duty to take into account in treating and handling this case. She talks about medical coverage guidelines need to be revised. Well, at the beginning of her answer brief, she said that they revise them every year. Well, they issue a new policy every year. And we never said that you have to include the medical coverage guideline for all diseases in every policy. The problem with this thing is that one problem is that they never even use the term medical coverage guideline or any defined term to refer to these. They use 3 different, the provisions that she says refer to them, use 3 different sets of words that aren't defined, and the policy itself states that if a term isn't defined, it has no special meaning. So you're telling people, oh, well, this is going to control over a specific medical diagnostic coverage provision. It's all going to be negated by something that they never even refer to in any way that's understandable to somebody who doesn't work for Florida Blue or is intimately, familiar with their claims practices. The policy, she says that you can change coverage within a medical coverage guideline, but the policy says differently. The policy says you changes to the policy are done by endorsement, which it says alternatively is an amendment, and that's defined, and it's not a medical coverage guideline. Their references they claim are to medical coverage guidelines it never identifies that this is an external document. In our case, we look at those words and say, oh, it's got to be medically necessary, and we can rely on our coverage and payment guidelines. The 7N looks like a guideline as to what is covered, and and it deals with medical issues, and it deals with IGF-1 in detail, and it's reasonable to construe that as being their position on IGF-1. Now, she points out that in that article they said that IGF-1 was used in connection with diagnosis of growth hormone, and it's a measurement that's taken, and it corresponds with some cases, probably maybe a majority of cases of growth hormone deficiency. But we're talking about the practice guidelines from 2007, 2009, 2011, years before this policy, years before this claim, all say that a low IGF-1 is not required for a diagnosis of GHD, and it just means that you have to do stimulation testing. But the fact that you don't have an abnormally low, and as I pointed out, Cass Law's IGF-1 was below median, but it wasn't abnormally low. But the guidelines all say you don't need an abnormally low IGF-1 if you have an established cause and a confirming history, which we have the history of these chronic symptoms going on for years after the traumatic brain injury. And so there was ample basis for the diagnosis of GHD due to TBI.
Mr. Brock, are there age restrictions on the use of the growth hormone?
No, I think there are situations that apply to children and situations that apply to adults. Zach Cass Law was, I guess, technically a minor when he first had the TBI, but when he was diagnosed with GHD, I believe he was an adult. And I would just mention, she keeps talking about discretion. None of the cases she cited for discretion were insurance cases. You can't give an insurance company discretion as to decide what's covered. I mean, that becomes a contract where you're paying for something and they can just say no. I just think that, and secondly, this contract doesn't provide, it says they must apply the contract definition of medical necessity. And contract provision states that it's in accord with generally accepted standards of medical practice.
All right, Mr. Brock, your time is up. If you'd conclude.
This contract is ambiguous. It's reasonable to construe 7N as being a medical necessity determination with respect to any requirement of IGF-1, and the category which Zach Cass Law falls into, it does not require one. And
all right, thank you, Mr. Brock.
Contract doesn't.
Thank you, sir. All right, thank you both for your argument, and we'll be in recess.
Thank you so much.